Hey everyone, so excited to see you all today. We have an incredible session planned for you where we're going to be talking about O-1 and EB-1A strategy. We're joined by a very experienced attorney and actually someone who's been on the other side, who's worked with the USCIS for several years. My name is Nikin. I'm one of the co-founders of Open Atlas. We have an upcoming summit next weekend that we are very excited to be collaborating with Manifest on. And for those of you who have already bought tickets for the summit or who are thinking about attending, this session is kind of a teaser because you'll get to hear from Evan on stage. Evan will also be available for one-on-one consultations during the Open Atlas Summit. So that's August 21st, 22nd in the Bay Area. It's going to be in San Jose. So that's Friday, Saturday next week. But without further ado, I'm so excited to bring Evan to the virtual stage. And he has so many insights packed into this session. Any of you who have questions, please feel free to use the chat function. We'll answer them in the order that we received it towards the end of the presentation. So thank you, Evan, for being generous with
Sure.
your time, with all of the insights you're going to share. And
Yeah, definitely.
we can get started.
Yeah, I'm glad to be here with you and looking forward to the summit. That will be just a tremendous experience. So, we'll talk about EB1s, just to give you a little bit about myself. I've been in immigration law for over 17 years. I worked for the Administrative Appeals Office at USCIS. The last case type I adjudicated was the extraordinary ability petition. Just a brief overview of that. When my branch chief brought me into her office, she pointed to she had some scales like you see behind me, and she basically said this case type is very complex and very difficult because you're weighing so many factors here. And so we'll talk about some of those today. And I know it can seem like a very daunting case type, but we'll go through that and then your questions at the end. Okay, so O1 and EB1 basically have the same framework for extraordinary ability cases. The major difference is O-1A is a temporary non-immigrant visa and requires employer sponsorship. We'll get to some of those details. We'll talk about the differences in them and how the standards are different. That's one of the main points. Okay, so we'll talk about some of the things the officers look at in these case types, as well as defining the field, and then other details like expert letters, the final merits determination. That really goes towards more of the EB-1A, which leads to the green card. As we'll also talk about RFE triggers. I will say at this point, it seems like most cases are getting RFEs, but these are just some things to be aware of. Okay, so a strong profile is part of this. I mean, it's a, very important part of this process, but a petition really needs to reflect that. And so you need to make sure that you're not just focused on, the career that you're in, the field that you're in, but really documenting the specific details of why you qualify for this. So officers are looking at several things. Principally, do you meet the regulatory criteria? But throughout this, they have in the back of their mind, does this show sustained recognition and that you're at the top of the field? And then when you look at this fourth point, very accomplished individuals still get RFEs and occasionally denials if a case is not presented correctly. So, how you qualify is meeting 3 of 10 criteria for the EB-1A, the I-140 petition, or 3 of 8 criteria for the O-1A. This is basically the starting point that allows you to get to that totality determination. We use that term more for O-1s. For EB-1A, the phrase we use is the final merits determination. So basically, those principles that we're talking about, the sustained acclaim that you've risen to the top of the field, that's what comes into focus at that totality or final merits determination. It's very subjective, and that's one of the challenges with this case type. Okay, so some of the differences, the EB-1A does not need a job offer, so you don't need a sponsor. There's no perm, no process with the labor certification. Um, so this basically means you don't have um, to quit or take other steps. You can file this on your own, and depending on what country you're from, that will, you know, help you understand the time frame for when you can obtain your green card. Okay, so here's some of the differences. The O-1A requires either a U.S. employer or a U.S. agent. Now, there is a way that you can actually have an ownership um, in your own. I mean, you can have an ownership interest in a company that can sponsor you. There are just some details you need to work through with that, but that is a possibility. Um, the O-1A allows for dual intent. It's quasi dual intent just because this statute doesn't say specifically, like the H-1B, this is a dual intent visa, but it basically acts in the same way. So what that means is you can be applying for your green card and not have any issues traveling in and out of the US. So the EB-1A is a direct path to the green card. Processing times, you can see the times are quite long here with regular processing, about 12 months for O1, 23 to 24 months for EB-1A. With premium processing, it's 15 business days. And now, just one thing to keep in mind, if a request for evidence is given, that clock will stop and then another 15 business day clock will start once you respond to that. As far as dependents, the O3 is for the O-1A, but the spouse can't work. For the green card, the spouse and children are included. Okay, so the current climate, this is the challenge, and this is really the difference here is that there's just such a more strict standard given for extraordinary ability cases. So 91% approval rate for O1s. The EB-1A, it's at 41%. And that has been fluctuating. This is from the first quarter this year. So what you really want to make sure is that you're in the strongest position possible when you file, but also uh, we'll talk about some of the things you can do to ensure that you can get an approval. Okay, so the first step, as we discussed, is focusing on these criteria. Did you meet at least 3 out of 10 or 3 out of 8? And then from there, the officer goes to the final merits determination. So you really want to have your petition split up into those two segments. Many times I find it helpful to actually include some highlights. I call them final merits highlights along the way. So it's helping the officer, it's persuading them little by little as they go through that process. Many times RFEs happen at that final merits determination, but there are also aspects of this step one that are triggering moments. We'll talk about some of those that sometimes an officer can see an issue and it just brings to mind some language that they're used to using. Okay, so basically the criteria is the floor. And now there's a few ways to look at this because the more criteria that you meet, the stronger your case is. But there's a risk here in that if you present additional criteria, but you just don't have strong enough evidence for them, then that brings the entire case down. So a petition that has 3 or 4 criteria that are very strong with the supporting evidence, that will be better than something that has 6 or 7, where a few of those just tend to be kind of riskier criteria that you've included. Okay, so um, the ways officers look at this, and there's a variety of ways to look at this, and many times I go into more of the psychology between different personality types with officers. But one thing you need to keep in mind is that these officers are reading through a lot of documentation, and they just can't help but compare your case to the others that are before them. So there is this comparison aspect to this. One of the challenging things that I saw when I worked at the AAO is that sometimes very strong cases did not appear that way by the way it was presented. And there were a few cases I just had to spend a really long time going through it before I realized, oh, wow, this really is checking out. So the other thing to keep in mind is these officers aren't experts in your field. So you really need to, I don't want you to water the case down so much that it loses its strength and the specific details about what you've accomplished. But what I would suggest is discuss those technical details and then go the step further to really explain what that means to someone who's you're really not informed in that field. So defining the right field is a challenge here because you're trying to show that you've risen to the very top of the field, but you also don't want to narrow it so tightly that you almost lose the officer with the arguments that you're making. In essence, you want to have a theme throughout. If some of the evidence is not lining up well with your field, sometimes we see this in the judging category that people will have judged the work of others, but perhaps the paper that they've reviewed really does not line up well with their field. That can be a problem. So basically, you want to start with the general aspect of your field and then narrow it from there. So, for example, here, our team narrowed a case from an AI type representation to AI chat-based dashboard architecture, right? So it's narrowing it a bit further. So your best evidence is really what you want to focus on. This is another thing that I'll say just from a former adjudicator's perspective. You don't know what the officer is going to spend the most time on. They could be landing on some of your evidence and staying there for a few minutes. And so if you have weaker aspects of the documentation you've provided that they land on, that puts you in a difficult position. Now, one of the challenges here is that many times there are confidential aspects of your evidence that you can't submit, or you can only submit portions of it, or sometimes the full details of your impact can't really be demonstrated. And so in those instances, I would recommend that you look at trying to piece things together in a variety of ways with support letters and other documentation. Independent experts are very important to use, but you also need to recognize that some officers take the viewpoint of, well, this person is being paid to write this report. So in essence, every attorney will prepare one of these cases a little bit differently, but it's just good to consider putting your best evidence forward as much as you can. Okay, so here's a look at the criteria. Basically, you'll see on the left commercial success in the performing arts, as well as artistic exhibitions. Those are the two that are not included on the O-1A side. So basically, what I would suggest looking at these criteria is the different ways that your recognition is shown. And this is one thing that I think sometimes officers overlook is that the statute describes this classification using terms of sustained national or international acclaim. Then the regulations that further describe how someone is eligible for this, they state you establish sustained national or international acclaim, or you demonstrate that your achievements have been recognized in the field by meeting at least three out of these criteria. So what we want to be doing is reminding the officers that the aspects of a claim that come out of these awards is listed as lesser recognized national or international awards. That's probably the most prominent for the acclaim aspects. Another one that really is prominent in acclaim is this one down here toward the bottom, published material about you. That's in professional or major trade publications or major media. Then you look at some of these others, leading or critical role in distinguished organizations. That has an acclaim aspect there with the distinguished organization. So we'll go into some of these in more detail, but those are a few thoughts. But I would also say some of these others go more towards showing that you've risen to the top of the field. So you really want to be showing both aspects of this in your presentation. Okay, two of the most challenging and the most helpful criteria are what we're going to discuss now. Original contributions, and then we'll get to leading or critical role. So this one is basically outward facing, external recognition for your accomplishments. So your contributions must be original and they must be of major significance to the field. And this is where it's just very difficult to establish what that means. And the language that you may see in RFEs is that USCIS says we want to see how wide the impact is to the field. Now, one thing I'll say here, we have the language major significance to the field. The actual regulation says significance in the field. So I'll make sure we correct that going forward. It's a slight detail, but in essence, you need to show how you've been influential in the industry, and this is, easier said than done. So, for example, patents come up quite a bit. USCIS says patents show the originality of your work. They don't necessarily show the impact. And so you want to be showing the adoption, how it's been influential in the field. Okay, leading or critical role, this is more internal, right, to the organization. The distinguished reputation adds to that acclaim. But basically, you're looking at two things. One is a leadership position and the duties you have. And you can claim both of these, but what I would suggest is looking at which is the stronger of the two, and does one hurt you if you include both? Sometimes officers take an approach to only focus on the weaker part of a case. So if your evidence for critical role is very strong, but they come back at you in a request for evidence focusing on the leading role where you're perhaps supervising three or four people, in that scenario, it may not have been the best time to introduce the leading or critical role. So basically, the higher you are in that leading role, that puts you in a stronger position for the final merits. But basically, you'll need a hierarchy chart and showing just how impactful you are as a leader. Let me actually go back one thing. So with the critical role, you need to show that basically you're indispensable to the company, that the contributions you are making are furthering the major objectives of the company. So, but it can also be to the division you're working in. So I don't want you to feel like you have to be like practically a founder here, but you do need to make sure that it's a very impactful role that you've had. Okay, so Some of the other things to pay attention to with awards, you want to document the selection process. In all of this, you're basically trying to show what sets you apart from others. And another aspect of this is also showing independent media that covered those awards as well. Membership, this one is a challenging one to meet because there's several layers to it. It's for memberships that are given because of your outstanding achievements in the field. So just something you pay dues for, that's not going to be sufficient. Published material about you and the focus needs to be about you and your work in the field. And recognize this needs to be not just like promotional type material. We want to see that others are viewing you as an expert. They're inviting you to uh, basically present yourself to the world and to their audience. Judging the work of others, this one can be viewed by officers as one of the lower tier criteria. So you want to make sure that you're showing high levels of um, accolades with this in terms of the reputation of the event that you're judging for, or demonstrating that um, basically that this requires a high level of expertise in your field. That one can be very good at showing that you've risen to the top of the field for those reasons. And then scholarly articles, this is another way to showcase your expertise in the field, also adds to the acclaim. Okay, so basically, as I mentioned earlier, you really need to separate these two, um, and sometimes there's some overlap with contributions you've made to your company when they have an external influence as well that can be used for original contributions. So as much as you can, show metrics that establish the impact of your role. And if you can even do a before and after, what was the company doing before you joined and took on this role, and what does it look like? How transformative were you for the company now that you've joined and performed that role? Okay, so expert letters. This is a challenge now because AI programs write so well. And officers, I imagine, are becoming a little bit distrustful, just having a little bit of skepticism on, well, you know, did ChatGPT write this or is this legitimate? So what I would suggest with this is make sure that what you're presenting is authentic and accurate, and that it really is connecting the dots together well. You also don't want letters that just repeat, the same topics and the same details that you're providing over and over again. You want to ensure that there's value with everything that's being presented. The other thing that I would say with this is with every supporting letter that you submit, you really want to try to find what USCIS refers to as pre-existing independent objective evidence. What they mean by that is sometimes I use the phrase as real-time evidence, an email corroborating some of the things that you're discussing. A message internally from a colleague that's you know discussing some of the things that you've accomplished. There's a variety of ways to do that, but you really need to show the officer with that real-time evidence as much as you can. Okay, so with the letters of recommendation, especially for critical role and leading role, letters from colleagues or managers, those can be very helpful because those people know uh, very intimately how effective you've been. And so it's good to have those, but also it's good to try to have independent experts and others who are aware of your work, perhaps somebody that you connected with if you've given a conference presentation or something similar that is able to discuss your work. Both of those can be very helpful. There's really not a set number of these that you need, but most petitions end up using between 3 and 7. Remember, the officers have limited amount of time, so you really want to make sure that they're impactful. So what makes a letter strong? Basically specificity, measurable outcomes and not talking about things just generally that you're a brilliant engineer or but really shows them what makes you a brilliant engineer. The letters also connect your achievements to the legal criteria. Now, the challenge here also is you want to make sure that you're not just repeating the regulatory language. And so there are some nuances in how to put these together, but these officers see these over and over again. And so when they just see that language over and over, it tends to I don't know, just be a little bit watered down. Okay, so connecting the evidence together, basically, this is where you're just making sure the themes are coming through, the recognition in the field, also that you have risen to the top of the field with your expertise. Some criteria, as I mentioned, can strengthen others. And sometimes there can be some overlap that you want to be cautious about. For example, if you've won an internal award, be cautious how you discuss that, because if an officer quickly going through it may be thinking, oh, they're claiming the awards criterion, and it takes them off track a little bit. So you really just need to be careful that you have a cohesive argument uh, throughout. Okay, so common RFE triggers, basically spreading evidence too thin across too many criteria. Another downfall can be the letters that are vague or just describe the person but not their impact. Critical role claims without documentation about the organization's distinction. That's a common trigger. Original contributions without the evidence of that impact. Or sometimes original contributions are basically a reiteration of the leading or critical role claim. And so that can open the door to an RFE. Salary, you need to aim for the showing that you're in the top 10% in your field. And so you don't want to just say, it's this much above the average, but really go to that high level. The other challenge is, citations from colleagues rather than third parties. You really want to make sure that it is not coming across that you're just trying to check off boxes here. Okay, so preparing for the final merits determination. This is really the most important part, and this almost gets overlooked in terms of it's like running a marathon preparing for one of these cases. You've gotten so far, and by the end of the marathon, I haven't run a marathon. Tried to uh, get myself to that level, but for some reason I can chase a soccer ball and run that way, but running 26 miles is challenging. So, but I imagine when you're getting to that end, you just want to stop and just walk the rest of it. And sometimes that's how it may feel preparing this. But the final merits determination is really this most important step that you want to take everything that you've already put together and then build it out to show the officer what it means. Don't just expect them to say, therefore, this is what it means. You need to tell them that. And so you're going to reiterate, here's the criteria I've met, and here's why it shows that I've risen to the top of the field. Here's why it shows my achievements have been recognized in the field. Here's why it shows sustained national or international acclaim. If there are aspects of it that don't have the national acclaim, then don't say that, right? You need to really make sure everything that you're stating is lining up. So there's really not a checklist for this. The officer is weighing a lot of things. There are things that the officer may not even put in paper on paper in an RFE or for a denial. And some of those things may have been very impressive to them and helped them move closer towards an approval. So that's another reason why these are challenging cases to present. Because the other side of that is you can present something that may not fit very well in the criteria. It may be impressive to the officer, but on the other hand, a particular type of officer, I call these more like the checklist types. They may say, well, it doesn't meet the criteria, so we're not going to consider it, right? So you just need to balance these things as you look at this. Basically, um, here are some things that you want to be asking yourself. What did you do? Why did it matter? How can you prove it? And who can validate it? Many times I break this down into a very simple way of saying, what shows that you've risen to the top of the field and how many people know about it? That's what you're trying to accomplish, right? And so these profiles are built over time. And I would say have the mindset that these are helping you develop yourself in your career as well. So even if you feel like you can't meet them now, I would suggest you work towards them. See what you can do to move towards some of these. And sometimes it may open up doors to meet other criteria, uh, but over time, it may help you have a much stronger case to present. Okay, so key takeaways, three criteria is the floor, not the finish line. You really need to focus on this final merits where the cases are mostly won or lost. Quality beats quantity every time. You need to make sure everything you're submitting is high quality. There's also a balance there because you need to make sure that you're meeting the regulatory requirements. So that can be also something to keep in mind as, you may have a seemingly weaker piece of evidence that meets the criteria. We'll try to combine it with another piece of evidence after that to fully build up your case. Okay, and then just as we've mentioned, the framing is quite important here. Okay, so I know that was long. There's a lot to talk about with these case types, but we'll turn it over to you. I've seen some questions come in the chat, so we will go to those now. And Nikin, how do you want to do this? Do you want me to just go through them or do you want to read them
Yep.
out?
I can read them out just to make it
Okay,
easy. And
yeah,
if anyone's not on video, it'll be helpful for
yeah,
them to just hear it out loud. So
sounds great.
the first question we have is from Shubham. What data are the percentages of O1 and EB-1A approvals based on? Is it the percentage of cases that Manifest processes? Does Manifest have an internal filter for which cases it files with USCIS?
Okay, good question. So we're pulling these details from the data that USCIS publishes, and then we also have access to data that Lawfully puts out, where they are basically receiving real-time details from people who have filed these cases and viewing the statistics that way. And so these are not internal numbers, but basically, we wait for when USCIS puts out the figures. That's the most accurate form of this. But what I would say overall with this, I know it's not part of your question here, but one challenge with this is just that you don't know what all these cases were compared against. And so what I suggest you really try to remember is overall you're competing with yourself. You're trying to get yourself at as high level as you can, recognizing that the officers are going to be comparing your case with others. Okay, we can go to the next question.
Thank you. Carol, hopefully I'm pronouncing your name correctly, asked a question. How hard is O1 versus EB to NIW? My priority date is current.
Okay,
Maybe there's a
great
few things to
question.
unpack here, right, Evan? Yep.
Yeah, great question. And I wish I knew more about your scenario, right? We are seeing EB2 NIWs have become very challenging. I would say overall, EB2 NIWs, the national interest waiver, is a more subjective case type overall. And so, in essence, I mean, even without knowing the details of your case, if you have strong evidence that you can meet at least three out of the eight requirements for O-1A, that seems like a better approach to take, but it really depends on what your proposed endeavor is, what your experiences are overall for the EB2 NIW. So that would be a great question to discuss with an attorney on a consultation.
Thank you, Evan. Saksham
Mhm.
asked, can lack of letters weaken my EB to NIW or EB1A case? I'm an undergrad with three research publications, strong judging, open source work, but I don't have more than one to two letters of recommendation. And are there opportunities for me to mitigate this with independent experts? And what are my
Yeah,
overall chances?
yeah, good question. And what I would say is, at this time, I guess you could say this is a silver lining in your case that actually this is probably the best time for you to proceed without having a lot of letters of recommendation. In other words, years ago, it was, I think a lot more weight was given to them. And I'm just speculating with my comment I said about AI. But I guess even as I prepare these cases and I receive a letter, sometimes I wonder, what was this written by AI, or can I trust it to submit it? So I don't think it necessarily means you're going to have a weaker case overall. What I would focus on though is as much as you can persuade those providing these letters of recommendation to include very specific details that show the officer this is a real person who's behind this, and the details are really well connected to your work. I would focus on that, and then um, and basically look at the other aspects of your case with the strong judging experience, the open source work. Those are some challenging things to work with, mostly because officers view the judging criteria as a lower threshold. So um, it's one of these things that I think you can work through this, but it would be a good idea to ensure that your strategy gives you um, a unifying message about your expertise.
Thank you.
Mhm.
I would ask a good question. How important is having recommendations on a letterhead?
Well, letterhead adds a lot of value to it because it takes the thoughts out of the mind of the officer that about what I said with AI. It basically humanizes it more, and it adds a little bit of an evidentiary filing. An example I give sometimes is that when I've submitted affidavits before in other case types, just having that notary stamp on there, it just adds a lot to it. In terms of this is an official document is what it seems like. I know it doesn't become an official document magically just with the letterhead, but it does add some value to it. So if possible, try to have it on letterhead.
Thank you. And
Mhm.
Saksham asked a follow-up question, but I think it's helpful to kind of generalize this. Is if someone has perhaps a strong case, but not a strong petition yet, because the quality, quantity of evidence isn't that much based on the criteria you covered, what are the steps that they can take on their side to strengthen their
Yeah,
file and
yeah,
petition?
this is a really good question because that's really the dilemma here overall is how we showcase your accomplishments, especially when for many years, you probably have not been aware of these requirements. One of the things I tell people at times is to do what I call portfolio digging, where they go back to their, you know, past memory bank, even just thinking through what are the compliments I remember people giving? What are the times that I've been acknowledged for things that I've accomplished? And see where that leads you. Sometimes it can be just a very small piece of evidence that you're able to dig up, or perhaps you remember someone who can write a letter of recommendation for you. So it's a challenge overall, but what I would suggest is continue to look for ways uh, to gain more recognition in the field. Now, you also have to be careful here because the officers don't want, you run the risk of, for example, if you do a number of judging things and have some published material about you right before you file, it tends to look like you're just trying to check off boxes. And so that's why you really want to try to document your accomplishments over time and demonstrate you have been accomplishing these things all throughout your career. But there are some times where you do just have pockets of time where, for example, you might have performed a leading or critical role for a certain period of time, and you might have had a high salary for a given time, but for whatever reason, you don't have that now. You can still highlight those and demonstrate that overall, this is showing that you are at the top of your field. And so I would just do a lot of brainstorming, a lot of digging, a lot of preparing um, to meet even more of the criteria to further establish your recognition. The recognition component is so vital here because some officers just get so focused on that sustained acclaim, national or international acclaim. But I would just remind I hope, I mean, there are USCIS officers listening, but I would hope that they remember there are regulations, that there are criteria here that flesh that out. Congress did not just say sustain the claim and that's all you need to show, and so just keep that in mind. There's just some of these principles to work through.
Thank you. Senthil asked a
Mhm.
question, but let me just add to that. Senthil's question was, how do we prove major significance for an unreleased product or contribution? But just to add to that, let's say someone is working in a company and they're contributing to something as part of a team. So how do they capture or show attribution to like a product or project? And could you share some examples related to that?
Mhm. Yeah, this is a good question. And what I would say is to show major significance for something that really has not been released yet is going to be challenging. The way around this is, if you're able to demonstrate well, let me rephrase this a little bit. So one of the challenges we have is sometimes people think of original contributions of, okay, you helped create a tremendous product that now is in the households of individuals all over the US. And so it's having a major impact. Well, just that alone, that's really not fitting in here with the language from the regulations because we're talking about major significance in the field. So what we're really referring to is not how the product has been impactful to the consumers, but how you have been impactful to others in the field. How have you influenced their workflows? How have you developed something that is creating a ripple effect in the industry? And so, but this is again why this is challenging because, I mean, one of the reasons you file patents is to protect your ideas, your work product. And so then to demonstrate, well, how big of an impact has your product had, right? That's a very challenging part to this. So, you know, um, basically, what I would suggest is recognize that original contributions is the absolute most difficult criterion to meet here. And sometimes the strategy that you may take is I want to present this because it shows a high level of my expertise in the field. But perhaps it might be better for you to just have the officer focus on what it means in the final merits. Now, sometimes you have to be careful that doesn't backfire, that sometimes officers will say, well, you can't have it both ways. If you're going to address it, we're going to address the requirements of the criterion. Well, what they should be doing is an actual totality of the circumstances view. But anyway, with with an unreleased product, you really want to look at how can you demonstrate the influence you've had to others in your field.
Yeah, Senthil did provide some more context in follow-on comments, but he mentioned that he had an RFE for his case. And one of the
Okay.
pushbacks was that USCIS challenged that he was working for like a distinguished organization, so that
Mhm.
leading and critical role criteria didn't count. Is that a challenge that you've seen happen, or like a
Well,
pushback that you've seen happen in RFEs? Yeah.
yeah. I'd like to see his actual question. I'm trying to understand. Tell me a little bit more. So they're saying that this is better aligned with the leading or critical role criterion.
Yep.
Is that
Let me
right?
read out this question. I got an RFE which was
Okay.
clearly written by AI, so they are in on the game too. I have patents for a new startup and funding. I'm critical because I'm the founder listed in the funding docs, but they countered saying that my startup is not a major organization, so the critical role doesn't count. Are you aware of
Okay.
any templated replies when you have funding for a new proposed startup?
Okay. Yeah. W- So this is an interesting scenario, and actually, what I would suggest is that there is some language in the USCIS policy manual that you can look towards in this way, um, which talks about startups and also I'll say comparable evidence is something that's viewed much more reasonably than when I was adjudicating these cases back from, well, 2019 is when I left. So um, what I would do is first go to the policy manual. You can do a search on that or even have a consultation with us about this. But basically, you want to guide the officer to this point of, you know, your funding, the things that you are doing at this outset, even at an early stage, that still should be able to uh, enable you to meet that part of this, even in the comparable evidence standpoint. So. Yeah, there are some challenges here because you're really talking about three things here. We're talking about a comparable evidence piece, the leading or critical role, as well as the original contributions. And so yeah, I'd like to chat with you more offline on this, but I think for the sake of the other question, let's see if we can get to other questions and hopefully that at least steers you in a direction on this.
Sounds good. Yeah. Isha asked a question. What is the latest with the O1 and EB1 processing delays at the Vermont Center? And what can applicants do about it?
Yeah, so one thing so I imagine this is a regular processing issue. So I'm going to make a statement here that's probably a bit controversial, but if you remember, there was a time where Apple was sued because they were slowing down the older iPhones, right? Um, Trying to encourage people to buy the latest model. There's part of me that thinks that at times USCIS tries to, or it just happens naturally in a way where they take their focus off of the regular process cases because they have so many of the premium processing cases. And so anyone can bump up from regular processing to premium processing at a given time. So these things are always fluctuating. If you go to our website or follow us on social media, you'll find some of the reports we put out about processing times. The times I conveyed in the presentation were about a year of a wait time for the O1s. So I would just say it's really difficult to predict how long these things will take. So um, the challenge is the longer you wait, you know, the more difficult it is to decide, okay, is this the time for me to now bump it up to premium processing? And perhaps you want to have a consultation about that as well. But I would suggest start with that.
Yeah. Thank you, Evan. There are a
Mhm.
few questions along these lines, so let me kind of generalize and ask a broader question. What are your thoughts on evidence from another country? So let's say India, like previous work experience, patents, authorship. Is there particular weight applied to evidence in the US versus evidence from another country?
A good question. What I would really focus in on with this is the more that you can present materials from several countries puts you in a much stronger position because you're further establishing the international context. So something from your home country certainly will be helpful and impactful, but if you're also to show that you're having an impact on someone else in another country, that even strengthens it even more. In essence, I wouldn't say, don't rely on the evidence just because it does come from your home country. This is part of your story. Talk about the journey that you've taken. A personal statement is actually part of the EB-1A cases in that you need to demonstrate you plan on continuing to work in the field. That's a great place to discuss your journey and the things that you've accomplished. Um, and that said, I would also just look at even other ways of finding an external reach internationally. For example, if you can look for those who have cited your work and try to see what countries are they from. If you've given presentations that have an international component to them, even virtually, highlight those details as much as you can.
Thank you. Pooja asked,
Mhm.
I have two letters of recommendation from my telecom industry experience and another two from my healthcare industry work experience. Does it matter from a case presentation perspective to have letters of recommendation from the same functional domain?
Yeah, it's a good question. And this goes back to ensuring that your petition is consistent for the field. So if the impact you've had in both of these industries is you know, related, then it's fine to use those. But you do run the risk of this being almost like a trigger issue that an officer would quickly jump on this and say, well, wait a second, something's not adding up. Let's do a request for evidence. One thing also to just state here is that requests for evidence buy the officers more time. And so they're looking for any reason they can to submit an RFE. And so you really want to limit that as much as you can, limit those triggering types of things. So you really need to weigh out, well, how much do these other letters um, impact the case? If they don't really add a lot of value to the other letters that are more consistent with what you're presenting, then I would suggest not including them.
Thank you. Heli
Mhm.
asked, what about international hires? What are the chances to get considered for an O-1A or EB-1A by self-petitioning and getting support from an employer?
Okay, well, this is challenging to discuss because I don't know enough of your background, and you know, it I guess I would need to know a lot more details
Just to
about this.
generalize this question is, have you
Yeah,
seen employers for international talent hires supporting an O1 petition and even an EB-1A petition?
yeah. So it is uncommon, but I remember adjudicating some when I worked for the government, and so it does happen, and um, they. I mean, they fit the mold just like any other case type would. So, it really comes down to what you've accomplished more than that particular perspective. I will say this, unfortunately, some officers do take a viewpoint of, well, this person's on H-1B or they're on in an F1 status. They could just go ahead and get their PhD and these other things. And I always thought that was something that was out of bounds, that officers should not be saying anything like that. They have one job and it's to adjudicate the petition before them, right? So, um, but it's one of those things that you look at the psychology of this, and hopefully, officers aren't considering those types of things. But that said, you also don't want to go overboard with saying, something like, "This is my only chance." You just need to present the facts. This is a very it's such a balance of a combination of objective and subjective details that are all merged together, and so you really just need to do your best in the position you're in.
Thank you. We are
Mhm.
almost at time, Evan. Do you have a few minutes? Because we have
Yeah. Mhm.
questions.
Yeah.
Amazing. Thank you
Mhm.
so much for being generous with your time.
Sure.
Sandeep asked, what is the current EB-1A denial percentage? Do you have any idea which USCIS center is rejecting a higher percentage of applicants compared to other
Yeah.
centers?
Yes, Texas. So when I worked for the government, I was always suspicious of things that came out of Nebraska, and I'm sure this is probably going to get out at somewhere. Well, the tables have turned. So Texas it has stricter adjudications, it seems. Right now, this quarter one uh, statistic is at 41%. So it's not good. Um, we're continuing to monitor that, but we're also assessing that. I'm assessing that every time I get an RFE, we're seeing some language that seems to be a little more strict than the language we've seen before. And so you do need to recognize things are tightening up a bit, but there's also some avenues here. Sometimes litigation in federal court is will open up the door for USCIS to pull back. One other thing I say at times is for new officers that are being trained on this. I know when I was first adjudicating these, I had a more strict adjudication those first few months I was doing them. But as time went on and I became more experienced with them, it really started to go up. And so hopefully over time, officers do become a little bit more reasonable in their interpretations. But it's just hard to say. There's a lot of luck involved in terms of where your case gets picked up, what officer picks it up, as well as the luck of what were the other cases the officer was looking at during that week.
Absolutely. Ashok asked, how do we use patents that have no commercial agreement or licensing behind them? Do they help the case, and what would we need to show to make them count?
Yeah, this is a really interesting question because it's a dilemma, right? Because patents, it's such an impactful thing to you for you to be part of, showcases that you're at the top of the field. Um, but without that impact, without the details of showing what USCIS wants to see, you're just going to continue to see this language that shows, well, this shows the originality of your work, not necessarily the impact. So you may consider utilizing it for something to strengthen another part of your case. For example, critical role that you were picked to, if you were picked to be part of this team to develop the patent, and you go towards how much that helped the company perhaps secure more funding, or, I mean, a variety of things. I'm just giving examples, obviously, but if you go all in to strengthen some of these other criteria and then reference it in the final merits analysis, that may be better than trying to meet the original contributions criterion. So again, there's some just unique components to this. One other thing that's a challenge here is some officers may start making a snap judgment just by the criteria that they see you're claiming. And so, you can be tempted to say, well, I want to claim these five because I want original contributions to be in there. Well, that's really good for that initial impression the officer has. Okay, this is going to be a strong case. Five criteria, original contributions is in there. But then you don't want that to be deflating to the officer. Well, they say, "Oh, I guess it wasn't as strong as I thought." Right. So these are just some other things to keep in mind. But perhaps strengthening another criterion is the best way to go.
Thank you. We have a few questions along the same lines, so I'll kind of
Mhm.
combine it into one question, which is
Okay.
if someone is early in their career, how do they go about building a case for an O-1A and then eventually an EB-1A?
Mhm. Yeah, great question. And some positive aspects that I'll point to in the USCIS policy manual is it does state specifically, even someone early on in their career can establish the acclaim needed to meet this. So that's one positive because when I was adjudicating these cases, people wanted to see you had strong positions of acclaim for like 15 years or so. So I'd start with that, but then also recognize this is a growth moment for you. This is a time for you to get outside of your comfort zone more than you've ever been, perhaps. This is for you to be talking about your accolades with everyone and anyone, almost like an author would. When you publish a novel, you're telling people about your book because you want everyone to help spread the word about it. So, the other thing that can come from that is organic invitations. The more you get involved in basically building your profile, building your expertise and helping others know about it, the more likely you are to get invitations to be interviewed on a podcast, to present at a well-known conference, or to engage in high-level judging or these other things. So what I would suggest is look at all of the criteria and then just do a lot of Google searches. What can I do um, to try to obtain this type of evidence and develop myself in that way? Now, if something does not really align well with your goals in your field, look at the ones that do and go all in on those. Like we were saying earlier, rather than having kind of seven watered down criteria or a few that don't really align well, it's better to have ones that are strong.
Absolutely. SK asked, how much time is normally spent by the officer for case review? Will they go through every detail or just read things selectively?
Yeah, selectively. So we have an attorney who used to work at the premium processing unit. He said it's about 4 hours, at most 6 hours, the officers are spending on this. Now we do what we call ex-USCIS officer reviews, where we have a few of us review the petitions that other attorneys have prepared, and we try to stay within that 4 to 6 hour time frame, and we can't do it. I mean, it's hard to do it because we read through everything, we go through everything. So the answer is you really need to make what you're presenting stand out because they just don't read through everything. And I was even trained by an attorney who said, listen, you don't have time to go through everything. Just pick out what goes towards what you're seeing. And so what I would suggest is, you know, if you have impactful evidence, you want to include it, but try to have it organized in such a way that the officer can get right to it. Perhaps, it's a very good idea to underline details, especially with electronic filing now. One thing I really like to do is use red underlining in Adobe, and it really has aspects of a letter of recommendation stand out. It can be challenging even when I've looked at a letter of recommendation and I'm trying to find out where's the part I need to highlight. It can take 5 or 10 minutes sometimes just to find where that paragraph is that you're looking for. So you just want to make sure your evidence is not just buried in a pile for the officer to dig through. The other thing I'll say just briefly is that some officers go right to the evidence. And so that's why I say even underlining portions of the evidence can be very important because if they're not reading through your brief, that's a challenge. And so I find it's really helpful to make sure that both the brief and the supporting evidence are very clear and they support each other well.
Absolutely. Aryan asked, and I think there are quite a few students who are joining us today. I'm currently an F1 master's student in neuroscience research, and I'm planning to do a PhD. What should I do in upcoming years to qualify for an O-1 or EB-1?
Well, one of the challenges with this is as far as publishing goes, because publications can be scholarly articles can be a very prominent thing to do, but you also have to be cautious in that some officers say, well, I expect to see this number of citations and this number of publications. But what I would say is, um, develop as much of that as you can. If that interests you to be publishing scholarly articles, if you're looking to really do a lot of that research component, go all in with that. If your focus is in another area, focus on that. So what I would suggest is really try to align this on a dual path with your career as well as these criteria. And that way, even if your case is denied perhaps initially, but you've still been furthering your goals with your career, it's not as deflating. But also keep in mind, this is a game of perseverance. Many times people are denied the first time, but then they turn around, file again, and then it is approved. So really what I would suggest is look at all the criteria, the things that you can do. Published material about you is a very important one because it's very clearly going to your acclaim, your recognition in the field. Um, Many times, we have these moments where we tend to think, well, I don't see myself ever doing this or that. Well, give it a shot. You never know what might come from it. You might not think you're going to give a keynote presentation. Well, prepare to, take the steps to get to be the person that could do that. And similar with awards, look at what are some of the awards that you can obtain. And sometimes it can be even the comparable evidence. If you're able to secure certain grants and funding because of your research, that can be a comparable evidence similar to some of these other things like original contributions. So, and again, original contributions can also be based on your scholarly articles that have a certain level of citations. One example I give though is that it's just like a viral video. Someone can't, they may want their video they're putting up on YouTube to become a viral hit, but it has to happen naturally. And so what I'm suggesting is take all the steps that you can put in place, the things that you can control to allow these other things to happen naturally. And that should put you in a stronger position.
Absolutely. And iPhone, not sure who's behind it, but asked, actually, before I asked that question, how are we on time, Evan? It's
Yeah,
3:10
that's fine.
Pacific. Okay,
Yeah, if we
perfect.
can go for another 5 to 7 minutes, that would be great.
Got it. Yeah. iPhone asked, does USCIS keep a record of applicants who file and refile? And does an officer know the petition history?
Yes, and this actually is a confirmation from this attorney who worked in the premium processing unit. The officers are required to review that prior decision, but you also have to be cognizant of the fact that the officers can be influenced by that, and even it might make their job easier if they are going to issue a denial. They can use in some of that language that the other officer presented. So I don't want you to be discouraged from trying the first time, but basically, you really do want to make sure that you are as ready as possible to make that first impression a strong one. And, in even if it does get denied, but you still recognize there were a lot of strengths to your case, I would suggest that you don't give up on that as well, because I remember reviewing many cases that have been denied before, and I just thought, wow, that officer was really strict on this or that point of view. And so a new filing, uh, usually you want to have a slightly different strategy, and that can also put things in a new light for the refiling. But basically, it is a challenge. with the process.
Awesome. We're at time, everyone. Thank you, Evan, so much for sharing all of these insights and just being very generous with your taking time to answer questions. And for
Sure.
everyone here, you'll get a chance to meet Evan in person next weekend in San Jose. We are organizing the only summit of its kind around high-skilled immigration. We're so excited to be partnering with Manifest, and Evan's going to also be available to take one-on-one consultations. So don't miss the chance. We'll send a copy of this recording, slides, and also a consultation link after this webinar. Hope to see many of you in person soon. And once again, thank you so much, everyone, and thank you, Evan.
Sure. Yeah.
Thank
Have a
you so
good night,
much,
everyone.
Evan.
Sure. Take care.